So guys, welcome to Tsaaro Exclusive Webinar, the Transfer Impact Assessment. And we are going to discuss today how it is done. So today's session, we have a special speaker for you, right? Which is Pulkit Vohra, right? I know Pulkit from quite a few years now, and we both have kind of, I think, seen our journey into privacy. And then that is something that, kind of brings back memories. And I think every time I call him also, the discussion is like, oh, we know each other for so long now. He's in British Telecom now, where he's the data protection officer there, and obviously looks at the Asia level of data protection over there. He is an expert into privacy. If you look at Indian market, I think a few people are there who know as much he knows in context to an international GDPR, CCPA level of compliance, the amount of knowledge that he has in depth today. Right. So we're very grateful, first of all.
You're too kind, Akash.
So that is Pulkit Vohra for you. And I already know that out of 125 people, already a lot of people know him already. A bit about me. My name is Akash Singh. I am also co-founder of Tsaaro. Tsaaro kind of deals with a lot of privacy work, data protection work, and also we have an academy. So both the things that we run, we try to make sure that we kind of bring a better privacy infrastructure for the world. So today's agenda is we'll discuss what a TIA is, what the need of a TIA is, how it is done, right, with a template, and considerations that are to be done while conducting a TIA. So what is a TIA? So the TIA kind of is born as a terminology after the SCC, right? The standard contractual clause. So what happened is in international transfers were happening, right? Schrems II came in, right? Schrems I came in. So a lot of data transfers got stopped. And when a lot of data transfers got stopped, right, European Union, right, the data protection authorities wanted more enhanced, stringent regulations on international data transfers, because the data that stays in EU, right? So there we have no issues. All the 27 countries of EU, 30 countries of EEA, we are good with them. But once the data kind of travels outside of EU without an adequacy level, right, or an BCR, then a TIA kind of comes into a picture every time. So TIA is kind of a questionnaire, right? Like a PIA or a ROPA. I think ROPA is not a questionnaire, but a PIA, I think you can compare it to a PIA. So now when we kind of look at a TIA, a transfer impact assessment, it always comes in before we sign a standard contractual clause. That is the logic behind it. Okay. So basically every time I'm planning to transfer data outside of EU, or even if an Indian company is trying to bring data from EU for processing, we kind of sign an SCC, right? It can be an entity to entity agreement. It can be an external vendor agreement. And again, it depends in privacy world, but still, right? The moment you transfer data outside of EU as an entity, you kind of need a TIA. Okay. That is the bottom line. So Pulkit, my question to you is, how do you look at a TIA? I think the first of the questions is, what is TIA, right, according to you? And why is it so important according to you?
You all guys would know what PIA is, right? Privacy Impact Assessment. So why do we do a PIA? We do a PIA to assess privacy risk in our new project, in our new application, so that we implement the right set of privacy controls, right set of privacy measures. So similarly, we do a transfer impact assessment. So now transfer impact assessment could be a part of a PIA or can be a separate exercise. But the whole idea of doing a transfer impact assessment is to just understand what adequate security and privacy measures the destination country to which you're sending the data to provides. That doesn't mean, when I say destination country, that doesn't mean the country level security measures. It means, suppose if you're sending the data to a third party in a destination country, what that third party in that country provides in terms of technical and organizational measures. If you're doing it internally, I mean, you can always do a transfer impact assessment even if you are transferring data within the same organization but to a different country. Organizations, technical and organizational measures could change depending on which country it's operating on. We have different TOMs than what we have in UK, just because of the difference in privacy regime, difference in privacy maturity. So because of these differences, when you transfer a data from one country to another country, it becomes important that you do an assessment so that you can assess those risks, do that mapping of TOMs, and then come up with a decision whether the transfer impact assessment is the right thing to do or not. or is it allowing you to transfer the data to that country or not. If it's not allowing you to transfer the data because of certain reasons, because of certain privacy regime in that country, you need to build some controls. So the process is same whether you do a PIA or a TIA, but the idea of both of them are different.
So I think that is very fairly explained. I will also kind of take one quick question here for you. So what is an onward transfer? I think that's a great starting. If we can explain this in starting, it will make more sense. I think this is going to come again and again.
So onward transfer is the transfer from one country to another country. The source country to destination country is the onward transfer. We are transferring the data from the source country to the destination country.
Moving on to our next point, I think when SCC kind of got born out of Schrems decisions, when we kind of, and it kind of became more and more important when I think the US privacy data transfers kind of became dependent on an SCC. So would you like to kind of take that minute and explain us about a bit more about Schrems II and how and why standard contractual clauses became more and more important in our daily context if we compare it in last 3-4 years?
I mean, before talking about standard contractual clauses, as you can already see, the trigger of European Commission coming up with SCCs was a judgment that was delivered between a case of the Data Protection Authority of Ireland, that is DPC, versus Facebook back in 2020. And this was based on a complaint filed by Maximilian Schrems, Max Schrems. So he's a privacy activist in Europe who kind of looks at the different organizations operating in Europe and way of working in terms of privacy compliance. He made a complaint the CJEU, the Court of Justice for European Union, and as part of that judgment, in this case against Facebook Ireland, the CJEU decided to demolish the EU-US Privacy Shield. Now, EU-US Privacy Shield was a framework before which enabled the free flow of data between European Union and United States. So they held it invalid. But then, as a fallout from this decision, what the European Data Protection Board (EDPB) did, they released a updated set of standard contractual clauses for all the organizations who are processing data within Europe or transferring data outside of Europe as a approved mechanism of transferring that data through some standard clauses. Now, these standard contractual clauses, as the name says, they are a set of contractual clauses that every organization, every two organizations need to sign when they are processing data. So if there's an organization within Europe who wants to transfer the data outside Europe, the third party, or they need to agree on a contract with the originator of data who is in Europe. These contracts would contain some standard contractual clauses that the EDPB had released just to make sure that the transfer that is happening is bound to some privacy clauses which will protect the data rights of the data subjects, which will protect the organization as well. And this is all based on, if you read the Article 46 of GDPR, tells that the EDPB or the European Commission has that authority that they can release some standard contractual clauses as one of the approved mechanism of transferring the data outside of Europe.
I think probably one more point that kind of came through was Max Schrems. And I hope everybody here knows about Max Schrems, but I definitely want all of you, if you don't know about Max Schrems, definitely Google about him and you will unravel a lot more into privacy and why it all started in Europe. So considerations while conducting a TIA. So Pulkit, in a general context, right, whenever you would be doing a TIA, maybe even thinking about a TIA, doing it before or after. So what are these considerations that come to your mind first and maybe in between, right? Or maybe after that, like to check the TIA, whether it's right or not. So what are these considerations that you think about?
So basically there are three things. The three most important things that I considered when I do a TIA. One is what data you are transferring, what's the classification of data, whether it's general personal data or sensitive personal data. The second important thing is the country that you are sending it to, and that depends, and that's why we are doing that TIA, right? So to understand the privacy risks of transferring the data into that country. And the third important thing for me is the technical and organizational measures that we would put to protect that person's data during the transit and at rest in that destination country. There are some other things here in the slide which I completely agree with. But those three are the important ones for me. If you ask me, like those three are the things that I would first consider when I do a TIA.
Pulkit, when you also calculate the final risk, right? So end of day, a TIA's result is a risk, right? What is
Yeah,
that risk?
yeah.
It can be. So how do you first of all define risk? Do you also define it like low, medium, or high, or how? What is your metric when you're defining a risk as a result of a TIA after considering this?
I have a different way of doing it. I create a heat map, like a privacy heat map, where I kind of consider try to quantify the risk score based on the likelihood and impact of the data being breached or the data rights of the data subjects being breached. So depending on the technical and organizational measures the destination country provides, what kind of data we are processing, how are we processing it, I come up with point in that heat map. So it's kind of a, you can say, 6 by 6 metrics. Some of you might have seen it. So I come up with a point in that metrics to understand what's the likelihood or impact of it, and then basis on that score, I then suggest the basis of the controls that they can put to minimize the especially the impact. Likelihood is something that not really a concern for me. Even if the right likelihood is towards the higher side in the score, I would want to reduce the impact through the controls.
So, Pulkit, one more question that even I wanted to ask as well is when, let's say, we are transferring data and we I think the first thing that you pointed out is we think about what type of data is being transferred. Now my point number two is, I think, do you think that if we transfer a sensitive data, or let's say a profiled data, it obviously will have more risk, so it will have more implications in a result of a TIA? So can you also please tell us more about, let's say, the Indian transfer, because a lot of people here are from the Indian context, so whenever they would be doing a TIA, I think a lot of onward transfers may happen from UK or EU, right? So what do you think if, let's say, we transfer data of sensitive sort to India, right? What are those risks you think that may pop up or should pop up in people's TIAs when they perform their TIAs?
So it would be, for first of all, because we don't slap me when I say it, because we don't have a privacy maturity in India, then what we compare UK has or Europe has. The most important risk I always define in a TIA when the onward transfer is to India is the risk of a breach that is happening just because of mishandling of the data. Because we don't have that privacy maturity in an organization, the employees don't understand how to handle sensitive data. So that's a primary risk for me in a countries where it's not only about India, right? So it's in the countries where we don't have a privacy regime, we don't have a privacy law. So obviously we will not have that privacy maturity in the organizations as well. So it's kind of mishandling of the data by the third party or by the vendors who are handling our data in India. So that's a primary risk for me when I transfer the data in any of the country who doesn't have a privacy regime.
Right, Pulkit. So basically, it's not about India specific, but it's about a general context.
Yeah.
If there is not a privacy law, then the risk is that the privacy maturity is not enough while transferring the data. So, okay, that's a very great point. I will also kind of make sure to write these on my TIA. So, steps to conduct a TIA. We also have a TIA template that we are going to try and populate a bit, right? Not 100%, obviously. Time will not permit that. But definitely, we kind of think about steps to. So, Pulkit, again, pointing that out to you directly, right? What are the steps to conduct a TIA? Let's now take an example also. Let's say a company X is in EU, right? Now let's take that example. Now company X is in EU, and they want to, let's say, give their payroll out to India, which happens also, right? A lot of times they want a payroll processor in India, right? So they are going to transfer their payroll information to India. So that is, let's take that example as company X. What are those steps to, to conduct a TIA, right? That is my, and with an example.
Okay.
Yeah.
So you gave that scenario of the payroll, right? If the payroll is being outsourced to India. So first thing I would do is I would kind of list down all the, so why are we doing the transfer? What's the context and purpose of it? So that I have that clarity of why are we doing the transfer at the first place. The most important thing for me is to understand what kind of data is being transferred. Now, if you talk about payroll, in payroll, definitely you would have some sensitive personal data as well, because you will have financial information in the payroll, the information about the account of the employees, information about the salary data, information about the tax data. So it's important that in the TIA we categorize this data, like what is the sensitive data we are going to transfer, what is the general data we are going to transfer. Now, this classification would be different based on your organization's classification standard, whether you define a normal personal data as general personal data, or whether you define the normal personal data as confidential personal data. Every organization has their own way of classification, and based on that classification they have their own way of handling that specific classified data. So for payroll, you put down, like, you would need for contact you would need the contact information of the employee as general data, and then for sensitive personal data you need to process the tax data or the income data of the employee. The technical measures would be like, we are encrypting the data when we are collecting it. After we are collecting it in UK, we have the access control in place. We have assessed the privacy risks. So these would be the technical measures. Now, this is all about the origin country.
So the first question that I wanted to point to you is, what level of overarching legal risk if the data being sent to India from Europe? Because we only have IT Act. So what is missing which is causing the risk? So I think that answer is already done, that I think that privacy law is missing. Correct me if I'm wrong.
That's the case, but we can still mitigate that legal risk through, I mean, if it's an intra-company transfer, we can mitigate that legal risk through binding corporate rules. If it's a transfer between two organizations, we can mitigate that legal risk through a contractual agreement, which includes the data protection clauses.
On what basis can we decide whether privacy maturity is not adequate?
I would say absence of a privacy law, first of all. I mean, if we don't have a privacy law in a country, then we don't have that legal obligation or legal requirement to make sure that we have that data protection mindset in place. We are handling the data in a way which ensures data protection. The second thing is you can actually evaluate the privacy regime in your organization based on the training. So every organization now has kind of an at least once in a year privacy training program, privacy training course that all the employees have to fill or have to complete that day, so that they can understand what is the result of that training, how many people completed it within the due time, what's the score was like. The third thing from which you can understand the privacy maturity is cases or the incidents that you in relation to mishandling of data. So these are three things. Like, first thing is, you can absence of a privacy law. That's kind of an, in my opinion, a by default indication that the privacy maturity is low. And the other two factors are depending on an organization. I'm not saying every organization in India would not have that privacy maturity in place. Some of them would have, but then it depends on each and every employee's contribution towards the data protection, because you can't just say that an organization's data protection is only the responsibility of the data protection team. In my opinion, and I have said it in other webinars as well, is that each and every employee is part of a data protection team, and I call them as invisible data protection team. So all the employees are handling personal data of their own, of their customers, of other employees in some way or another. So we all have an equal responsibility to make sure that the data protection is being taken care of. And if we are not doing that, we are not privacy matured.
Right. I think there's another question that has been posted which says, if somebody has conducted a PIA, would TIA be necessary? I think they both are on a different context.
You would not need to do a TIA if you're already covering the necessary steps, or if of that TIA. If you already have a comprehensive PIA where you are also assessing the risk of transferring the data to another country, then basically what you're doing is you're embedding a TIA process within a PIA. So in those cases, you would not need to do it separately.
I think that kind of gives us more light to increase our PIA template as well.
Yeah.
So I think there's another question. So do the TIA vary from region to region? Example, will the
Mhm.
assessment be same for EU and for APAC? Because compared with GDPR, APAC don't have much stringent process in place.
Hmm, hmm. I mean, that's why we are doing a TIA, aren't we? I mean, we need to understand that difference between the privacy regime of Europe and APAC. If we are transferring the data from, let's say, Netherlands to Singapore, both of the countries' privacy laws are different. There are some specific requirements in Singapore's PDPA. So that's why we're doing a TIA. So to understand that risk, to understand those differences, so that we can implement the right set of controls.
Right. So I'll take one more question right now, and then we'll move to next slides. How can you integrate TIA into PIA? So usually TIA is done by businesses and DPO, and PIA is done by engineering team and DPO. Basically, people want to understand the difference and who does it, who's the owner of TIA or PIA.
There is no hard and fast rule, or there is no kind of a general rule that the TIA can only be done by business or a PIA can only be done by engineering team. I mean, in PT, PIA is done by business. It's not done by DPO. DPO just do a second line of assurance just to check whether the PIA has been done right or not. So it depends on organization to organization. The whole idea of doing a PIA, as I said initially, is to assess privacy risks of processing a data. It doesn't really it can, but it doesn't have to talk about the data risks when you're transferring the data across boundaries. Its whole purpose is to understand what kind of data you're processing, how are you processing it, where you're storing it, what are the TOMs that you're putting in place, and then suggest controls to mitigate the privacy risks coming out of a PIA. The TIA, the whole purpose of doing a TIA is to understand the privacy risk when you transfer the data. When you do a cross-border data transfer, that's when you do a TIA. Now, if you already have a cross-border data transfer question inbuilt in your PIA, you are basically doing a TIA by default. So I won't stick to the response that a TIA is only done by this team and the PIA is done by this team. It doesn't work like that. It can be done by anyone as soon as we are doing it rightly and we are assessing privacy risks and the transfer risks.
Right. I think well put forward in terms of, I think that differentiation and that integration, right, becomes an important factor for all of us. Now, I think moving on, right, what are the supplementary measures, right? I know you've already talked about it. You have told encryption, you've done pseudonymization, right? But if you can quickly just kind of point out to people that what are these supplementary measures that companies can have to kind of, advent of transfer becomes easy, right? The transfer becomes easy to that next entity, to that next vendor. So what can they do today? Also, a suggestion like a SOC 2 or an ISO would also help, Pulkit, if that
Yes,
makes.
yes, absolutely, absolutely. Yeah. All of us kind of understand the technical measures like doing an encryption, doing a pseudonymization, doing access control. I'm making sure that security approves the architecture diagram of where the data is being stored, if it's stored securely or not. This we all kind of understand. But for me, the more important thing are the organizational measures. Now, when you're doing a transfer across the boundaries, the most important thing to do first of all is to make sure that you are doing it based on between two parties, between let's say BT and Cisco. Then you need to have a contractual agreement in place which kind of lists down all the data protection clauses which are approved by the DPO. I mean, because these data protection clauses would be different based on the country you're transferring it to and the country you're transferring it from. That's the most important thing for me, because then you're legally binding your transfer. You're making sure that you are legally secure. That second most important thing is, as Akash said, if you're doing it for to a supplier, making sure that you have done that check whether that supplier has a SOC 2 report, whether the supplier is ISO 27001 certified, ISO 27701 certified. So these all shows that the suppliers policy processes around handling personal data are there. They know what they are doing. And then so the originator of the data can also feel secure in transferring the data, and then we can tell this to our data subject that the supplier to which we are transferring the data, though we are transferring it outside the country, is a supplier that we have a contract with, an NDA in place. The supplier has the right technical and organization measures in place, so that subject also have that confidence of, if a consent is required, they are confident in providing that consent.
Right, Pulkit. And I think, Pulkit, that is exactly why we advise our clients, if they're doing business outside of India or even in India, they get a SOC 2. We help them get that ISO 27001. So I think that kind of makes a lot of sense. And also started happening is a lot of people, I think since the GDPR came in, that vendor assessment became very, very important. And in that vendor assessment list, the bigger company or the owner, right, they always have that metric behind where they kind of assess that risk. So if you have submitted these reports to them that you are certified, you can say that you were audited at a point in time, gives more confidence and brings you to a lesser probability of getting audited. But now coming to our important thing, Pulkit. So Pulkit, this is a template that we prepared so that people can actually get that sense of what it is actually. So and if we can run through this for, let's say, a minute or 5 minutes, what would you kind of fill here, so that people can get that sense also what actually happens on the ground rather than just talking about it. If you would like to run me through, I'll kind of keep scrolling and keep filling, right? And you can kind of help, and again we can take that example of that payroll company, right, which is transferring data to India, and we can
it's kind of same of what I said earlier. Like, first, what you need to do is just to define why you're doing a transfer, what's the intention behind it. So you put down some general information. I mean, we do it in a different way, but it's all same, the purpose of it. Then you put who's a data exporter. So data exporter means who's sending the data. So here what you can do, you can put the legal entity of who's sending the data. Yeah, it could be company X. Country of data exporter, like if you're doing it from India to UK, that would be India. Data importer would be, again, you can put the legal entity of, or the legal name of the organization who's kind of receiving the data. You can say company Y. The country of data importer, again, India to UK, so it would be UK. You can put, yeah, that's okay.
I am suggesting to do it from Netherlands to India rather than the opposite
That's
way.
okay. Yeah, that's fine. Yeah, so you can put data importer as India in that case.
Just to be clear. Yeah.
Right. The next one is, again, purpose of transfer, so payroll. What I would suggest here, I mean, what I do generally is just to be a kind of a bit descriptive of why you're doing the transfer. What's the, like, you define the purpose or why are you doing it? What's the business case of that transfer? Because that kind of shows the reviewer, who's generally a privacy team member or a DPO, of to understand why are we doing the transfer in the first place. Because this TIA could be initially filled by the business, so and then be reviewed by a DPO. So it's important to define the purpose a bit descriptively. The next thing is the categories of data subject. Again, whether it's a business contact information or so you can define all the personal data elements. So sorry, this is categories of data subjects. So whether they are employees or customers or contractors, the categories of personal data is where we would put the personal data elements. Next one is sensitive personal data. As I said in the example of payroll, it could be your income data, your tax data, your account information. So you put the sensitive personal data in the right section. So this is all done to kind of
In
understand
payroll,
what the,
but just checking with you, Pulkit, in payroll, there will be no sensitive data. No? I'm just asking.
there would be, Akash, because when you're processing a payroll, you need a data subject's account information, account
Okay.
number. You would
Okay.
need the tax information also
Yeah.
to kind of
Your tax ID will become, yeah.
yeah,
ID will become, yeah, makes sense.
yeah. Your Aadhaar ID might also be required to process payroll. I mean, because it's the Aadhaar ID and PAN is linked. So
Definitely.
to
I
process
was
payroll.
actually pointing out. So basically, I agree with you that India payroll data becomes sensitive in the Indian law, but in European law, in Netherlands, it kind of becomes non-sensitive.
Yes.
I
Yeah.
was pointing there. So
But
totally.
in that case also, Akash, it really depends on, so in the organization in Netherlands, what classification that they have put. Maybe they have said that the tax data or the account information data is confidential or sensitive for them. You either do a TIA based on the classification of your organization, or you do it based on the overarching law. So if GDPR doesn't say that the account information is sensitive, you don't consider it as a sensitive. The next one is around technical implementation. So how are you basically transferring the data? What are the implementation steps you have put to transfer the data, whether it's through SharePoint, whether it's through, I don't know, through a shared drive, or what is the kind of mechanism you're using in terms of the SSH or TLS. The next one is, as we all said multiple times, the TOMs in place. So you need to define the TOMs of how are you going to transfer the data. The next one is around relevant onward transfer of personal data. It's generally not, I don't really, was not relevant for me to understand that information doing a TIA. And then countries of recipient of, if there's transfer being done beyond, let's say, Netherlands to India, then India to somewhere else, then who are those recipients? Then you put down certain further information, which you call it as TIA parameters here: starting date, assessment period, like for how long you are going to do that transfer, whether it's an ongoing, it's for a specific time, like 1 month. Ending date. Then target jurisdiction would be, let's say if it's Netherlands to India, so it would be the India jurisdiction, the Indian IT Act or the SPDI rules. Relevant local laws taken into consideration. So this will be the local laws of the destination country. For India. So here, again, this section we call it something different, but here is something you need to be more descriptive again. So there are certain questions, like the first one is there a possibility of whether you can transfer the data to a whitelisted country? So now the whitelisted country is a country which has the similar level of privacy protection as Netherlands in this case. So is there a possibility to do that rather than sending it to India? So you kind of define that whether it's possible or not. So the step 3 is something that the business is filling for the DPO to understand whether the TIA is approved or not. So if you read the entire questions, you would get the idea of why are they important. Because of the time, we may not be able to help you understand why they're important, but they all make sense. So just for the sake of time, Akash, what I would like to do is just take up questions because I think there are many. The participants can have a look at that template later, and if they have any questions, they can either directly reach out to me or to you.
Okay, perfect. So I was about to say that, but I was just in a hurry. So I also wanted your knowledge. So I was also like, as much as I can.
Yeah, no, I get that. But I think it's important for me if we take up questions because that's a good way of understanding.
Okay. So TIA is a self-assessment or has to be approved by a regulator?
Is it a question? Or you're answering?
It is a question in the chat, so I have to ask you.
Okay, can you repeat that? Sorry.
So I was asking whether TIA is a self-assessment or needs to be approved by a regulator.
No, it doesn't have to be approved by a regulator. It's kind of a self-assessment that you're doing it just to make sure that you're transferring the data in the right manner.
Okay. When special personal data is being transferred to from EU to India, which laws can be considered in India for protection?
If sensitive personal data is processed, is it?
Yes.
There are SPDI rules which came into effect in 2011. So those rules specifically talk about processing sensitive personal data and putting certain measures in place. So I would suggest if you just Google SPDI rules, you'll get that link. Section 43 and 76 of the IT Act kind of talks about the criminal convictions around processing sensitive personal data and what can happen if it gets leaked. But the important thing in Indian context are those SPDI rules. So that would be the main.
I think when we are doing our TIAs with the clients, right? I think this is exactly what we fill it with, and even a few more things that are client confidential, so can't be shared here. But yeah, I think totally with you here. I think I'm go to the next question. People have a lot of questions. Okay, somebody has asked what is TOM.
Technical and organizational measures. So again, technical measures could be encryption, access control. Organizational measures could be policy, and ISO 27001 certification and all of that.
Very good question by Pooja. If there is a conflict between the overreaching law and the company's classification, will the stricter rule prevail?
It should prevail. I mean, that's something that an organization decides in terms of their privacy program. Most organizations, what they're doing right now is seeing GDPR as a gold standard. So especially the European organizations, they build their data protection policies and processes based on GDPR because they see it as a gold standard. So I would always suggest you take the strictest law in consideration when you're processing personal data, if especially around cross-border data transfer.
When you have multiple countries as data importers, would there be a separate TIA for each, or can we have a consolidated TIA?
It depends. Like if it's for the same purpose, we can do a consolidated PIA. But if the purpose changes for each importer, we need to do a separate TIA. It's all depends on the purpose.
Okay. So we can edit that template in a way where we are kind of pointing out importer countries, and then in importer country laws, we kind of put that section saying India, and let's say saying Nigeria, and then let's saying those three countries. Would that be the point? If you look at the template and we kind of try to visualize this, Pulkit.
Yeah, makes sense. Yeah.
Should a TIA be conducted if data is transferred from India to EU?
Yeah, I mean, again, just to clarify, the TIA is not done if the data is transferred from EU to non-EU countries. It can be done if the two countries are involved. So there is no rule. I mean, it's not by the EDPB or it's not defined by GDPR that the TIA only has to be done between EU and non-EU countries.
EU is, but I think there's one thing that, a lot of people ask me, where do they get the best template? So my suggestion is OneTrust data guidance, right? If let's say anybody here is already using OneTrust, they can take that. That is the best template. Otherwise, obviously, they can reach out to us also. We can help it out. So if EU is exporting data to India and same data is being transferred from India to Uzbekistan, okay, should the last chain also have same level of production under TIA?
Okay, it's kind of a complex situation. So we need to first understand. I mean, I'll not be able to provide the answer right now, but it depends on why the data is being needed to transfer from India to Uzbekistan. If the data originator in EU has a requirement to send it, so send it further to Uzbekistan, they can consider that Uzbekistan as an importer within the same TIA. But if the party in India is kind of engaging a sub-processor who is in Uzbekistan, then what they need to do is to do their own TIA between India and Uzbekistan. So it all depends on kind of an engagement between the three parties here in EU, in India, and in Uzbekistan.
Makes sense. So guys, before, we just have 5 minutes left. So I know you guys love our webinars and seminars. That's why you're here. Also, I think Akansha has kind of posted in the chat for our upcoming webinars. We are full with webinars next week. Anything that relates to you, don't miss it out. We have international speakers as well this time. We're going to talk about a lot of things in depth. So don't miss out on this, right? Do register yourself. I'm just looking for a few more questions if I can find we have missed.
So one question was if TIA is annually, or the second question was on same thing when the TIA has to be done. Or so the answer to that is there's no defined frequency of when the TIA has to be done. When there's a data export that's going to happen to outside country, and for a new purpose, you need to do a TIA. So it can be 20 times in a year, it can be 10 times in a year, it can be 5 times in a year, depending on when you're exporting the data. So generally, what I suggest, when you do a PIA, if you my 2 cents are, you do not need to do a TIA separately. Because it's challenging for the business also to fill up another form. It's challenging for the data protection team also to review another form. And define your PI in a way that it covers all the TIA aspects as well, TIA parameters as well. So you only need to worry about one form, one review procedure for any new project, any new application. But if you're not doing it, you don't have a comprehensive PIA. You would need to do a TIA every time you do a PIA if you are transferring the data across boundaries.
Okay, last question is for you. right? And I wanted to read it.
Pertinent legal questions on sections prior to doing a TIA for Uzbekistan, as it a country categorized as primary concern for AML risk by the US Department. Just sending it.
So it's accountable.
Yeah. I mean, again, I'm not a lawyer, so apologies there. Okay, that's it.
I actually, same thing happens with me sometimes. So I just wanted to see
Yeah,
maybe
that's the problem.
how to
I mean, that's the
explain.
only advantage I feel being a privacy risk professional than not being a privacy lawyer.
Yeah, I think that's interesting. I usually call it, privacy kind of end of day becomes engineering once we start kind of implying to it, right? So that kind of helps a lot because everything kind of goes back to that data transfer, goes back to that PIA, goes back to that access control, right? So without security, I keep repeating this, right? There is privacy becomes invalid. So, but yeah, overall, guys, first of all, I want to thank Pulkit, right? He's very busy. It's very difficult to get his time. And he has agreed to give us time today. So thank you, Pulkit, for an amazing session. And
Sure.
thanks for answering so many questions for so many people in such a short time. Thanks a ton for this.
No problem at all. You can always, guys, reach out to me on LinkedIn. I'm quite active there, so you can directly message me there and I'll respond.
Right. So, guys, Pulkit's LinkedIn is here in the chat, right? So if you want to connect with him, so thanks a ton, Pulkit, for joining us, and we will see you in more sessions as always,
Yeah.
right?
Thanks for having me, Akash.